Spontaneous Quickie. Increasingly from prosecutors and the news media, and spurred on in popular culture like Law and Order, we see assertions from prosecutors insisting on a fair trial or some other such phrase as an excuse to inhibit the rights of the defendant, including things like gag orders or denying access to discovery or witnesses. The problem is, it goes against the Constitution as it's been understood since the founding, and this was confirmed in 1987 with United States v. Ford. Congressman Harold Ford Sr. was accused of mail and bank fraud. He had gotten a few loans, and the state contended that the loans were actually bribes and indicted him. The district court issued a gag order against him sua sponte, prohibiting him from making any extrajudicial statement that a reasonable person would expect to be disseminated by means of public communication, including discussion of facts and evidence, any statement about any prosecuting attorney, the government's motive in filing the indictment, and anything involving the merits of the case. In other words, they stopped him making his case to the public that the court was corrupt and this was a political prosecution. That violated his First Amendment right, so he made an interlocutory appeal to the Sixth Circuit. The circuit agreed with him. They ruled, such broadly based restrictions on speech in connection with litigation are seldom, if ever, justified. Trial judges, the government, the lawyers, and the public must tolerate robust and at times acrimonious or even silly public debate about litigation. The courts are public institutions funded with public revenues for the purpose of resolving public disputes, and the right of publicity concerning their operations goes to the heart of their function under our system of civil liberty. Prosecutors have the bully pulpit, in addition to all of their law enforcement powers. So sticking a gag order on the defendant on top of that is not only a blatant First Amendment violation, it is the ultimate in unfairness. They ruled, the defendant's interest in replying to the charges and to the associated adverse publicity thus is at a peak. So is the public's interest in the proper functioning of the judicial machinery. The accused has a First Amendment right to publicly reply to the prosecutor's charges, and the public has a right to hear that reply because of its ongoing concern for the integrity of the criminal justice system and the need to hear from those most directly affected by it. In his first trial, the jury was deadlocked. In the second, Ford was acquitted. That demonstrates how important it is to make your case to the public and not let the prosecutor smear your name everywhere. As for prosecutors claiming these constitutional protections, they ruled, it is the individual defendant whom the Sixth Amendment guarantees a fair trial. It is the public to whom the First Amendment guarantees reasonable access to criminal proceedings. And it is individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our master. You know what? I'm just going to leave it at that.